Ms. Hausdorff, if you want to address the first one, you brought up the American companies, so if you want to, yeah.
Thank you, Keholach. These measures would necessarily, in the bill, create a government-required partial boycott of Israel. Now, that would force American companies based in these countries, so based in Ireland, to violate federal anti-boycott laws. The background to this is that since 1977, with broad bipartisan support, federal law has banned American companies from, and I quote, complying with, furthering, or supporting any boycott fostered or imposed by a foreign country against a country which it does not itself which is, forgive me, is not itself the object of any form of boycott. And that's 50 U.S.C. paragraph 4841. Now, those laws apply even to US companies doing business abroad. And of course, there are many large companies doing business in Ireland for tax reasons. As advised, I shan't name any names. But the issue here, of course, is that even if one of these companies were to represent to Irish authorities that it was complying with this proposed legislation, it would necessarily fall foul of those boycott provisions and the penalties associated with them I have already outlined. That is the severe danger that Ireland is courting, in my respectful submission. As far as Ireland's reputation more generally is concerned, of course, the economic consequences of this aside, Ireland is at pains, and positively so, to present itself as a positive place for international companies, American companies, to do business. This is not the image that I would suggest Ireland ought to be putting out to the world. And of course, the grave breach of EU law, which I hope we will have the opportunity to come on to analyse in due course, certainly because I fundamentally disagree with some of the evidence that has previously been given to this committee in the pre-legislative scrutiny stage. That, of course, does not paint Ireland well in the international arena. If it is unilaterally exercising national policy in flagrant violation of the common commercial policy exclusivity that the European Union enjoys. So for those two reasons, but of course many others, which I'm sure we'll come on to discuss, this will undoubtedly have a damaging effect on Ireland's reputation internationally.
The second,
Chairman, if I could just add two sentences to that is relevant, because it directly arises out of your hearings. What I was astonished to learn, well, I followed your hearings involving departmental officials, and I'm, like Natasha, familiar with the United States law, is both federal and state law creates huge difficulties for American companies operating in a state that boycotts a single state such as Israel. But what I was astonished to discover was, I think it was Mr. Keown from the department who was asked appropriate questions by a member of the committee. He said two things were said. He said the department hadn't yet produced its regulatory impact assessment and was only now having regard to and looking at the relevance of United States law to the draft bill. I would have thought that was an essential prerequisite before it was published, and I'd have thought that before this committee concludes its work, it's absolutely crucial that this regulatory impact assessment is seen by the committee, and the committee is fully briefed on the negative impacts this could have, not just on American companies located here, but in their expansion and new companies coming here.